We can go ahead and get started. Thank you for joining us for this webinar on structuring cost share for conservation on leased land. I'm going to give a bit of an overview, and then I'm going to hand it over to our presenters so they can guide you through this topic today. I would like to thank the Harry R. Hughes Center for Agroecology and the Sustainable Agricultural Research and Education Program that has funded this effort. So I work for the Agricultural Law Education Initiative. We are a partnership of the Francis King Carey School of Law at the University of Maryland, Baltimore, the College of Ag and Natural Resources at the University of Maryland, College Park, and the School of Agricultural and Natural Sciences at the University of Maryland, Eastern Shore. We are an Empowering the State program, and I provided our website there and our social media handles, and also our email if you'd like to get in touch with us. My cell phone number and email will be on the last slide, as well as the presenters' phone numbers and emails. There will be time for questions at the end of the webinar. If you have something specific, you can type it in the chat box, the Q&A box. We can try to answer it, or else we can try to address as many questions as we can at the end. So, conservation practices. Conservation practices are less prevalent on leased farmland. We know that about 43% of Maryland's farmland is leased, according to the most recent census of ag. The reasons for this are varied, and they basically break down to a lack of communication between the farmer and the landowner, leasing uncertainty, meaning the term of the lease is unknown, and that creates some instability in terms of a return on an investment. So if a farmer doesn't know how long they're going to be on the property, they are unsure in many cases whether or not they should be investing in that property. And then finally, a lack of knowledge of farming and conservation practices. So this is typically on the landowner end of things. So if a landowner isn't very knowledgeable about agriculture, or isn't very knowledgeable about conservation practices and all the technical assistance and the financial assistance, like we'll be talking about today, they're less apt to have that conversation with their farmer. So one tool that you can use to address this issue is a lease. A lease can be really valuable in this context. It can provide the foundation to implement the practices on a leased farm in a mutually beneficial way. In order to help folks with this process, we created the Agricultural Conservation Leasing Guide. And for those of you who attended one of our winter workshops, you learned about this tool in detail. But in case you weren't able to attend one of those workshops, basically the guide helps landowners and farmers with the who, what, and how of conservation on leased farmland. So who explains the roles of the state and the federal players, so explains the role of University of Maryland Extension, NRCS, soil conservation districts, and non-governmental organizations. The what is the leasing and communication strategies that parties can use, and the how is sample lease language for commonly used conservation practices so that folks can use that language in their lease in consultation with their attorney. There's many different ways that a lease can be structured to support conservation. Starts with communication between the parties, and there's a lot of those considerations outlined here, but the one we're going to focus on today is division of cost share. And division of cost share is important because oftentimes when conservation practices are put in place on leased acres, conflict occurs in terms of compensation for maintenance. So if a farmer is going to be given that maintenance responsibility, if a landowner expects the farmer to be maintaining that practice to certain standards, which we'll hear about today, based on the various programs, there are certain maintenance responsibilities that can have financial consequences. And so how is the farmer going to be compensated for that maintenance? And one of the ways is to think about dividing cost share. So we're going to be talking about landowners and farmers applying for cost share and potentially dividing that cost share and how that can factor into this whole process. To help us through that process, we have experts. We have Laura Pleasanton from FSA. We have Brent Kamoff from NRCS. He's a district conservationist. And we have Norm Astle from the Maryland Agricultural Conservation Grants Program. And I am going to turn it over to Laura to get us started today. So
Thanks, Sarah. If anyone has trouble hearing me or anything like that, please just speak up and let me know if I'm too quiet or if I'm yelling one way or the other. Please let me know. As Sarah said, my name is Laura. I work for the Farm Service Agency, and what I'm going to talk to you about today is mainly the Conservation Reserve Program. FSA has a lot of different programs, but our primary conservation program is obviously CRP. So when I'm talking today, it's only in the realm of CRP and CREP and CRP grasslands and things like that. So if there's anything you want to know about a particular situation, though, my preference is always that you go to your local county office, or if you're working with a producer, that they go to the county office specific to them. County offices know their local farms, they know their local farmers, and they know the ins and outs, and they're usually the best resource for anything farm specific. So in general, FSA, we have to be careful not to give advice, but rather we provide people with options, and that would be the same tone of what I talked to you about today. We try really hard never to steer people in a certain direction, but give them options and let them decide. So we can always share what our policies are, and sometimes if there's something where we're not sure how our county committee, which I'll explain the concept of them in just a little bit, if we're not sure how they will respond to it, we can float things by them to get an idea, and that's sometimes helpful if people are making decisions. So the FSA County Committee, it's one of the things that makes the Farm Service Agency a unique agency. They are a group of locally elected producers in each county. There's usually 3 or 4 of them. And they hold a lot of weight in overseeing the county office, and they use their judgment and their knowledge of the area and as growers to make decisions specifically for program administration in their counties. So one of the things that they oversee is landlord-tenant provisions, which we'll talk about, and participant eligibility. And they often are the ones who approve CRP contracts. So if there's something they're not comfortable with, they don't have to approve it. So they hold a lot of weight. So if there's any conflict between a landlord or a tenant for a CRP contract, the COC or the FSA County Executive Director, whoever's approving it, they just won't approve it. If there are any concerns, whatever, we'll just wait until things are worked out. Basically, the purpose of our landlord-tenant provisions is to make sure that, a landowner isn't able to just kick a tenant off the farm because he, wants to enroll the land in a conservation practice. He has to involve, it's his land. He can enroll in the program, but he has to offer that tenant an opportunity to participate and have a share of it and be a part of the contract. And likewise, it makes it so the tenant can't sign up for a program without keeping his landowner in the loop. So there has to be that mutual consent there. And then before we can do anything, each party has to sign a certification statement for us saying that, they're aware, no, they haven't been booted off the land, or yes, I've offered them an opportunity. So this is just a little snapshot of what the certification statement often looks like. This is basically straight from our 2CRP handbook, but many offices adapt it, and this is really just a random FYI if you feel so inclined to see it. And then this here is just the exact wording from our handbook. It's a brief 1,000 pages with rules. We don't have many at all, but this just talks a little bit about when people have to be provided an opportunity to participate, things like that. A little light reading for you. So in terms of contract shares, if you have landowners and tenants who want to do a contract either together, or the operator wants to, or the owner wants to, basically the contract participants get to determine the shares on the contract. The county committee won't approve them if it looks like they're designed to circumvent other program regulations. So for instance, you have a wealthy landowner who exceeds our adjusted gross income limitations and they can't qualify. We don't allow for them just to shove that off on the operator and they say that it's 100% the operator, but perhaps the operator's just turning around and giving them the money. If we think there's something going on like that, then we do not have to approve the contract. So we have that provision, but at the same time, that's where we have our county committees for judgment and things like that. So it doesn't mean that that's how we have to operate. So the landowner can have a 0% share and the tenant 100, as long as it's not a scheming device and as long as that operator who would be getting 100% actually qualifies as an operator in our realm of rules. But the landowner would have to sign at least as a 0%. So kind of the same thing, basically. The operator can hold the contract if they have satisfactory evidence, and that's determined by the county committee, to show that they will have uninterrupted control of the land for the CRP1 period. This can be anything from a statement signed by the producer. It can be a long-term written lease, or actually sometimes it's as simple as the owner signing the CRP1, because, and then when I say CRP1, that's our actual, the contract itself, because it has the contract duration on there. It has start and end date. So it's showing, okay, I'm on board for these 10 or 15 years. And then one thing is that the operator has to have operated the land for 12 months before making the offer, and that's similar to the fact that an owner has to own something for a year before they are able to qualify. One nice thing is that the payment shares don't have to be commensurate with previous annual rental payments or other agreements in the office. So say they're 50-50 on crop shares, or they're, ARC PLC contracts or something like that, that's fine. This is totally separate, and so we allow them to determine it as long as it fits within our rules. So like I'll keep saying, though, a 0% share is not an appropriate share for the person qualifying the land. And one thing worth noting is that if a landowner signs on for a 0% share, they aren't held liable for any contract violations. So it is on their land, and they've agreed to it, but if something goes wrong, they aren't stuck holding the bag. So I think that would make, a lot of landowners feel better. The division of the cost share for establishing the practice is also up to the participants. Once again, it doesn't have to match the shares on the lease. Of course, there's a lot more to think about here if they're installing, a shallow water area or doing wetland restoration or a riparian forest buffer than if they're doing, a 35-foot filter strip of cool season grasses. Sometimes we're talking tens of thousands. Sometimes we're talking, several $100s. It just depends on the practice and the acreage being enrolled. And then SIP and PIP, those are signing incentives that we have, and SIP is the signing incentive payment, and usually about $100 an acre. And then PIP is the practice incentive payment, and that is a bonus where they receive 40% of the eligible cost share money as an incentive. And those two incentive payments that we call SIP and PIP, they are paid according to the shares on the contract. So if you're structuring a contract, you do want to think about SIP and PIP. Two pretty hot topics in the CRP world for a lot of different reasons are maintenance and mid-contract management. And they are two things that when we're talking about, having landowners and operators work together, these are things that definitely need to be thought out ahead of time. You've got the maintenance, which is the annual maintenance, which is, an expectation where things have to be taken care of. There's usually, or I shouldn't even say usually, but there are sometimes small amounts of money built into the annual rental payment, but there isn't extra money for maintenance. So what we're trying to do is get people to kind of just see CRP from a different perspective and not see it as a way to make money with that annual rental payment, but a lot of that money has to go back into it. And that's what we need people to understand, because there are higher expectations than ever. We didn't used to monitor the program very well, but we are now, and there's been a learning curve. The program is, almost 35 years old now. So there's been a learning curve. We've learned a lot, and we've seen a lot of what we haven't done. So with that said, they need to think about who will maintain it. That can be anything from mowing to spraying to dealing with, frustrating woody growth that's creeping in, and that takes time, it takes money, it's a commitment. So they just need to think about who will be doing that and, communicate that expectation. So if you have a landowner who's signing up and the operator takes care of everything else on the farm, he needs to know if he's going to be stuck with that too. Or vice versa, the owner needs to understand that the operator needs to stick with it as well. And the other big thing to think about is mid-contract management. So right now, we've just started a new sign-up on the 3rd. And for now, just for what we're calling sign-up 52, there's not actually cost share for mid-contract management. It sounds like it may just be the sign-up, but either way, cost share or no cost share, there is an expectation that producers will complete mid-contract management at least one time throughout the life of their contract. The purpose of mid-contract management is to complete an activity that improves habitat for wildlife. We have a predetermined list of activities. It can be everything from light disking and then an overseeding of clover. It can be a prescribed burn. It can be, interseeding. It just depends. And that activity is decided between NRCS and the staff who are writing the conservation plan and the contract participants. So they decide on it. But it does have to happen. Every once in a while it gets slide because sometimes it just doesn't happen. But the majority of the time, or it's always a requirement. So it's something that they should anticipate doing. It's something that has been a requirement since sign up 26. And like I said, we're on 52, but we didn't used to do it. So it's not really always on the forefront of people's minds unless they've been working with the office recently. So this is something that takes time and money and trips into the office, and it's not always a big deal. And sometimes it's a good chance if the cover, needs clover, it's a good chance to get cost share and have it paid for. But my point being is that it just needs to be thought about ahead of time, and it needs to be a part of the discussion. And if there's hopefully a written lease, this would be a great time to write something like that down. All right. One of the things that we just can't forget is that CRP contracts are legal contracts with the federal government, and sometimes we make it really enticing to sign up. There will be incentive payments from the federal government. There will be the MBA signing bonuses. As I said, there's the practice incentive payment. So sometimes it's not too shabby to sign up, and you're getting the cost share to install the practice, and it seems great. But it's a lot less fun to get out of the contract. And if we're blunt about it, really the only way to get out of these contracts is usually death. Otherwise, you do have to, if you cancel your contract early, there are exceptions, but for the most part, if you terminate the contract early, a full refund is due all the way back. We are sometimes able to prorate it, but sometimes if you're in year 14 and you've been getting $10,000 a year, you owe back 14 years worth of $10,000 annual rental payments and the cost share that you were paid to install it and the signing incentive payments and liquidated damages. So it can be a very big deal. And while it's fun to sign people up, it's really not fun to ask for that check back. So we just want people to understand the expectations of the program and make sure that it's a good fit for them. So in that vein, just, we have to share, I think, the positives and, the pros and the cons. So if you have a landowner who sells the land and the buyer doesn't want to take over the contract, then it falls on the operator if they're the 100% share. So if the operator has 100%, landowner has 0, and the owner sells it midway through the contract, in our world, the owner walks away scot-free, and we're going after the operator for that money back. So like I said, that involves the full refund. So what I would encourage people to do is to make sure that if you have, if you're working out an agreement between landowner and operator, that this is written down. And sometimes it can be seamless because the buyer will want to take over, and that's great and that's wonderful. And in that vein, I would encourage the landowner or whoever's handling the land transaction to get it included on the settlement sheet or whatever other legal document would cover you, because what we do is we go hands off. And unfortunately, we ask for the money back, and then it has to be handled in civil court. I've seen situations where that happened recently. There was an operator who he was in probably year 11, and the landowner sold the land, and he was completely stuck. And the buyer didn't want to take over it. I think they said they were going to, but then they didn't. And there was nothing in writing. There's nothing there to help him. So he was stuck with it, and he had to pay it all back. But, you know, that's the bad side. But I've also seen a lot of opportunities where operators have had, you know, contracts for 15, 30 years, and it's worked out just fine. And that's probably because they have a long-term lease and they're communicating with their landowner and they have that good relationship. So it's definitely a great program to bring in revenue for, you know, the marginal cropland in the places where CRP is intended to be anyway. But it's just important to get something in the lease or something that'll hold up in court if the landowner were to sell and then the buyer would be unwilling to, you know, accede to the contract. Overall, the goal of our landowner-tenant provisions is really just to make sure that, be it the operator or the landowner, nobody's taken advantage of and that things are fair. So if you're looking to get into a CRP contract, you know, we have some ridiculous deadlines sometimes, and things are hurried and people are frazzled, but ask as many questions as you want. You know, take your time and, you know, make sure you know what you're getting into and that you have all the time you need with the FSA staff to make sure you understand. Let's see what else. Oh, one thing that is slightly different, but I think it became a hot topic at one of the meetings I went to, is adjusted gross income and program participation. So I just wanted to take a minute and talk about that, and then if you have any questions about it, you're more than welcome to ask me. So basically with AGI, adjusted gross income, right now it's $900,000. So if your adjusted gross income, I should say if the program participant's adjusted gross income on average for the prior 3 tax years is above $900,000, they are not eligible to receive program payments. They can actually participate though, but the caveat is that they still have to complete maintenance and management, and if they end up out of compliance, even though they're not getting any money from us, we are still going to charge or make them liable for liquidated damages for our troubles if the contract is terminated early. In that same manner, I suppose, state and county governments can also participate, but they're also subject to the provisions above, so they would also have liquidated damages. Now, with that said, most, you know, government entities don't re-enroll now because that's a lot to take on, but we have had situations recently where the government entities were awesome, and if they had bought a piece of land from an operator or an owner, they were flexible enough to go ahead and take over the contract for the little bit of time that was left to spare the former contract holder from having to pay everything back. So that was pretty cool. And I thought someone was going to owe back a ton of money, but they were great. So that's just something to keep in mind is, you know, you have to think about the AGI provisions, so people can participate, and if they're willing to, you know, be a little flexible. So that's what I have for the FSA perspective for now. You're welcome to ask me questions here or offline, whatever works for you. But unless anybody has anything to say, I'll go ahead and mute myself.
Thank you, Laura. That was really helpful, and there's definitely a lot to unpack there, but I think you did a great job highlighting some of the considerations for operators and landowners in the CRP context. I am going to hand it over to Brent, and he is going to talk about his perspective as a district conservationist in this process.
Sure. So thanks, Sarah. With NRCS, I'm going to kind of go over our perspective on our contracting work, our financial assistance programs that we do, and kind of let you know some of the things that have changed, because they have changed drastically, really at a national level, for how we view these things, hopefully for the better, realizing that these are tough situations that people are in dealing with, you know, absentee landowners and just the communication back and forth. So I'm going to hit our major financial assistance programs that we've deemed them, and really go through the different nuances there of what our expectations are. So the 3 that I'm going to go through are really the Environmental Quality Incentives Program, Agricultural Management Assistance, and the Conservation Stewardship Program. So I'm going to kind of lump the EQIP and AMA programs together because they're very common. The easier one first, AMA really offers financial assistance, but in Maryland here, it's been siphoned down to offer only a few practices, which end up being high tunnels and new irrigation. So when people sign up for that program, generally those are the only two things you're talking that are eligible through financial assistance. Whereas when you look at the EQIP program, which is our much broader, diverse financial assistance program, it offers financial assistance on the 128 recognized BMPs that we provide assistance on, such as the one you see pictured here of the grassed waterway. So there's a broad array of practices that we can do through EQIP, and that's generally the majority of the financial assistance dollars that we get in Maryland is generally going towards the practices we offer through that program. The stewardship program, a little bit different from the fact that it's still financial assistance. However, you know, from the other programs, we're really looking at issues that someone may have conservation-wise and how we can help them treat them. The stewardship program comes at it from a different angle of someone who's already achieving a high level of conservation, has addressed the majority of the issues they may have had on a farm. And so what we're really doing with that program is assessing the baseline of that conservation that has already been done. And then if you can meet a minimum stewardship level, beyond that, we're really asking you to exceed what our minimum standards are. So when you go through EQIP financial assistance, we're asking you to meet a minimum standard of a practice to install it to treat an issue. CSP would actually be enhancing that above that level and offering some type of more intense management of, you know, that practice. You know, maybe it's for pollinator habitat, maybe it's for wildlife, maybe there's other reasons why you're enhancing that practice. So the uniqueness of that program is when we evaluate that threshold, we then offer a payment rate for the acres that you're offering. We offer a payment rate also for those enhancements that you plan on doing, and put it all together and really give you kind of an acre payment for everything in your operation. I like to think of it as the recognition that we realize when people do these BMPs over time, you know, a lot of these BMPs we do are more costly to maintain than they are to initially install, and we're not there for that maintenance after we help someone install them. So to me, I kind of like to look at it as a good offset for that. That being said, when you look at our financial assistance programs, the contracting and the years and the time frames and things like that, when you look at EQIP and AMA, you're typically 1 to 10 year contracts, although I would tell you that we tend to stay on the 1 to 4-ish side for the sheer fact that once you sign a contract, the dollars for whatever practice you're doing is locked in at that very moment. So 4 years later, if the price of whatever material inflates, you will not get any price increase. So there's a benefit to getting contracts done up front in the earlier stages because those costs will hold true more so to what the prices were when you signed that contract. Whereas if you drag something out 10 years, there's a very good chance that inflation has really, really changed the dynamic of how much that project's going to cost you at that point to be done. The nice thing is about CSP, those contracts are set at 5 years. There's no changes from that. It's 5 years. It's always 5 years, and that's what it stays. So if I would have done this a few months ago, I would have significantly more slides. However, there was a recognition in this new Farm Bill that we were probably too restrictive on what we were requiring for any of our financial assistance contracts, really to the point of when you're looking at these practices and the lifespans and the contract length, we were always looking into the future to kind of verify that, yes, this person is going to be renting this farm for a certain length of time. The good news I would have to report is I think there's been a recognition from NRCS's perspective nationally that these practices on rented farms are very important. They are a bit more challenging to do because of the dynamic. And so we have really, really scaled back our requirements for what we need when working on a rented tract of land. So in our new policy, it brings consistency to all of these programs, and it does make it easier for the producer from the standpoint is we no longer look however many years down the road the contract is, we look from year to year. And if that person can demonstrate that control from year to year in several different facets, whether it be at application time or contract time or payment time, as long as we can do that, that person is perfectly fine, which offers a completely different dynamic for our programs of ease of doing this stuff. The other part that you have to realize is with these contracts, yes, we have a lifespan built into the practices, and yes, the contract might be 3 years long. We have a unique dynamic to where even though we ask people to maintain a practice for a certain lifespan, the reality is we're in a contract. Once we make our last payment, once the contract's over, we're really out of that picture at that point. There's not too many reasons or cases why we could go back on somebody for something that's not being maintained correctly at that point because we no longer have a contract. And really our only mode to look back into the past is really if someone comes in for an additional project in the future, that we would basically, in a ranking, hold them accountable for not maintaining something that we previously did that is with its lifespan, which I would also tell you, from our standpoint of contracting and getting this work done on rented land does make things a whole lot easier. So common issues that we see with doing practices on rented lands. Landowners always have the question, who's responsible for this practice? I still always tell people, because our policy got a lot more simple doesn't mean that you leave the landowner out of the picture. There still needs to be a conversation really between the producer and the landowner. I know a lot of times producers like us to have that conversation with them. The problem is that, if it's a waterway or something simple like that, there's a need for it. Everyone, no matter who's out there, someone will probably recognize, hey, that needs to stay, or we're going to have a gully again, so it stays. You get into the complication of there's practices we install that can't be removed. Once you put a pit in the ground, it's in the ground and it's there and it belongs to somebody. Well, I would physically tell you, even though the producer's working with us, even though the contract's through them, after this project's over and done with, if the producer decides to up and leave or gets kicked off of that land, he's probably not taking that manure pit with him anywhere. And so there still needs to be that conversation up front between the two parties of, okay, we're going to go through this. Here's who's paying for it or paying the difference. And then here's how this agreement is going to work out in the end, because that practice obviously is going to remain on somebody's land and can't travel. Another issue we've gotten into a lot with these programs is, and it's not necessarily the fault of the landowner. However, I've had a number of cases where we do all need all this paperwork signed by the landowner, and a lot of things are very common that people get it and say, yes, we realize that farmer needs to do that. We realize they have to pay a portion of it. Farmers are not getting rich. Farmers are not all wealthy. and they realize that, and they know exactly what needs to happen and go along with it. We also have a group of people that usually call and say, I want to know how much money the farmer's getting for this, and have the common misconception that, you know, we're either paying over 100% or somehow the farmer's making money off of this. And it's come down to, in the past, you know, farmers were reluctant to do these programs in the future because they've had their rent raised as a result of the landowner thinking they're getting paid to do something, and the landowner wants a cut of it. So again, goes back to, you need to have these conversations up front. The other part is, even if a person has a lease, which is fantastic, at that time in the year when we are doing contracts, where we're working on this stuff, we have a specific set of parameters at that one given time that need to be met. And, you know, that contract length, 3, 4, 5 years out from there, all of that needs to be specific and tied into that contract. Well, even if someone has a lease, it's very rare that that lease and the time frames in the lease and the parameters in the lease actually cover what our contract requirements are. So even though they have one, it generally may not correspond to what our requirements might be at that given point in time, especially if it's not new or if they're halfway through. A lot of the time we cannot use what they have as a lease anyway, which again goes back to why we've simplified some of this. So I'm going to basically take you through somewhat of an example, show you the documents of what this has been simplified to for someone to be able to participate. So at the time of application, this is page 2 of our application, and basically question 6 is going to ask them if they can certify control of land, and they're basically going to check one of those boxes. And if they're not the owner, they're going to basically write in there the, you know, number of years that they have an agreement through, and that might be a verbal agreement with the person. However, at the time of application, when they're submitting this, showing their interest in a program, that is all they need to do. That is them self-certifying that they have control over that land at that point, and that is good enough for us at that time of application to demonstrate that. So we'd progress through working on designs, plans, everything else for them to the point where we'd get to a contract. We would offer them a contract, and basically we'd have to obligate that money into their name to set aside. At that time, we again would verify that control of land, and there's also another document that we use for permission from the landowner to the tenant to install structural or vegetative practices. I think it was an option for CREP. We still present the option that if you want your landowner to sign off on the contract as 0% shares and have them involved, that would also demonstrate that at that point. We're fortunate in Maryland that a lot of our producers report crops. They do it with Farm Service Agency. There's a lot of people that participate with them. So we've deemed here in this state that the documentation that FSA uses, you know, to basically report crops, the producer farm data report where all of the producers' farms and tracts are listed as they operate, we, if available, which they are here in Maryland, we are able to use those to demonstrate from year to year that the producer is still farming that farm. And I'll go through that as a little bit of an example later to show you that form. So here is our concurrence to install structural or vegetative practices. Pretty straightforward. Tells you that these are all practices with greater than 1 year lifespan. It also says that we have the intent that these practices will be maintained for their lifespan, which again, I go back to, there's only so much we can do outside of the contract period. We list everything on here and their lifespans and what the practice name is, and essentially that's what the landowner signs and prints and dates. This is a new form for this year that they've come out because of this policy change. So it's very much simplified the process. So we get to the point where we have a contract, we are working through the contract to install these practices, whatever they may be. So we are then verifying that control of that land throughout the contract, regardless of how many years it is. We generally do a yearly contract review. On that contract review, we document that the person has control. We on there document by what means we utilized to tell whether that person had control. Again, goes back to as long as FSA records are up to date, we would use those. Our overall EQIP and AMA and CFP contracts, nationally, there's a random 5% spot check for control that we need to basically submit our paperwork at that level for them to review. A lease or legal agreement is still adequate if they have one. It meets those timeframes. But again, now this will be the first time where we're not actually doing it for the life of the entire contract. We will be doing it yearly. So again, I anticipate that process is going to be a whole lot easier when it comes down to that at this point, when we need to verify that yearly control. So the actual example that I'd show you that's filled in here, go back to that application, question 6. It's as easy as that person writing in those years of control at the time when they fill out that application, that's self-certifying at that point. So this is basically a snapshot of someone's producer farm data report that I was able to get. So basically, in this case, you can look, it tells you the state and county, the farm and tract number, the relationship to the farm, so owner, other tenant, operator. So this is all done on the FSA side for us. We're just pulling it from their database. And then basically, if the person we're working with is listed as the operator or other tenant, in that case is when they would need to provide that written documentation of being able to control that land, have permission to put structural vegetative practices on it. But essentially, as long as they are listed on this document, we can update this from year to year. As long as they're on here, that is basically the document that we're going to use to verify that they in fact still are on that farm. That's the permission form that I showed you a few slides previously that's just filled out. So you can basically see here in that last case I gave you, David Shriver was the person who we were working with. He was listed as the other tenant. In this case, he was also the applicant. They're listed all of the BMPs that we have in his contract. His parents are the owners of the farm, and so all we needed in this case was signatures from his parents verifying that they're basically acknowledging that we are doing that work on that farm, and they give him permission to do that work on that farm. Our yearly cycle of contract reviews, if you look at this farm, pretty simplistic. Question 9, is the land still under control of the participant? We'd check yes. And then in the box there, we wrote that we verified it by the producer farm data report in 2019 that still showed him being as another tenant on that farm. And then basically at the time of payment, we would acknowledge that same thing, that he's still an operator, still has all of the land that's wrapped into the contract as previous, and then we'd go ahead and make that payment. So that's the last slide that I have. Hopefully you see that recognition that we've had nationally to simplify that process at a great deal and make it a whole lot easier to really get some of this established on rented ground. I think the part that it's made tougher a little bit, which is always maybe the hardest part to have happen, there probably needs to be this format that we have probably needs to make the landowner and farmer communicate a little more about the terms and what they're each getting into, which ultimately I would still tell you is a good thing. That's the level it needs to happen at. It should not happen between us and the landowner basically letting them know what the farmer is going to do. They should be informing each other of stuff. And if anyone has any questions, feel free.
Thanks, Brent. That was really helpful, and we always like good news. So it's wonderful to hear about the changes in the program, and I just want to throw out a reminder that talking about communication, there are communication prompts and some strategies that are in that agricultural conservation leasing guide. So if any of you are helping farmers and landowners facilitate these communications, feel free to point them towards those resources. Hopefully those will help folks be able to have those conversations. At this point, I am going to turn it over to Norm Astle. And Norm, you should be set to go, and you should be able to progress through the slides.
Okay. Well, Sarah, thanks for having me. Glad to be here, and glad to be able to present. For the MAX program, just a little bit of background. It's been in place since 1984 as the Maryland Agricultural Water Quality Cost Share Program, providing grants to prevent soil erosion and to manage nutrients. With our program, the grants are up to 87.5% to install best management practices. We probably have more than 25 BMPs currently eligible for funding. Our budget right now for capital projects is $8.5 million. We have some other pots of money that we can use as well, but for the most part, we count on the $8.5 million. With the projects, we have a project limit of $50,000 per project and $150,000 per farm. These would be active projects, so if a project goes out of maintenance life, then you would be able to receive additional money. So that's sort of ongoing, you might say. As the projects expire, you can apply for more funding through MAX. For animal waste storage structures, per project, it's a $200,000 limit, and then a $300,000 limit for the farm. Let me see. As far as, I may back up just a second, though. We have general eligibility for our practices. The requirement is that there's a potential water quality issue that's on the farm that needs to be addressed. It's not necessarily to benefit farm production per se, not quite as much as NRCS or maybe FSA. We are trying to address a water quality problem. And it's primarily on agricultural use. We might request cropping history that it's been cropped 3 out of 5 years. If the project is based on animals, then the minimum number of animals that you need to qualify for eligibility would be 15 animal units. We would pay down to 8 animal units, but then it's prorated between the 8 and the 15. Okay. The MAX agreement is how we center our administration around the development of agreements. Sometimes we call it a contract. It has to be signed by the farmer operator, the soil conservation district, and of course MDA. The landowner also signs the agreement. So in regards to leasing, it's not something that the operator could do on his own. It does require the landowner's signature to participate. The project is being installed to address, as I said, a potential water quality problem that the district has certified in writing exists on the above described land. We do work in conjunction with the soil conservation districts. That includes NRCS staff, the local district staff. They pretty much administer the program for us, so we're working through them. We don't have, design or engineering capabilities within MAX that we rely on the districts and rely on NRCS for the standards and specifications. The districts are making recommendations what practices to put in and what to approve for eligibility for our program. as far as the farmers and landowners' obligations, once the practice is installed, they are required to maintain and use the practice for this project life as indicated in the agreement. We have 10 years and 15 years. And also the standards of NRCS has to be met throughout that project life. Part of the agreement, too, is to allow the district and MDA staff to inspect during the maintenance life. I'll touch base on monitoring just a little bit later here. But during the life, what the agreement requires is during the life to notify the department of beforehand in writing of any change of ownership or possession of the farm. In other words, if the farm's going to change hands, we like to know ahead of time that it is being sold so that we can transfer the practice from the old landowner to the new landowner. And how we sort of go about doing that, we require a recordation, which is basically a lien is placed on a property. MDA records these contractual agreements for the BMPs on the deeds for any project that costs more than $5,000 or above. When real estate is sold, the original landowner may be responsible for reimbursing the state for the cost of the BMP if the maintenance life is still active. So the BMP runs with the land. It doesn't run with the operator. So the operator could change, and then the landowner is still responsible for it. So it's a little different than from FSA. In the agreement, provides the department with a signed statement on a departmental form from the potential new owner or operator, binding that person to all the terms of the agreement for the remainder of the project life, and then return to the department the cost-sharing funds for which have been provided under this agreement. Again, what I'm saying here is that by agreement, and if the agreement is recorded in the courts, that agreement then transfers automatically to the new owner. We sort of nickname them automatic transfers, meaning that it was recorded, the new owner then picks up the responsibility. Sometimes they know it and sometimes they don't. Normally before someone goes to settlement on a property, sometimes maybe the attorney or the titling company may call us up and say, the lien references an agreement, what is in that agreement, and we normally send them a copy so that they know ahead of time what it is that the new owner is inheriting. If the BMP contract is not recorded on the deed, meaning that it's less than $5,000, the new owner may elect to assume the responsibility of the BMP maintenance, but he doesn't technically have to. So in that situation, then if the new owner does not take the practice over by contract, then we could try to seek payment from the original owner. When we go to pay out a contract, we typically just write one check for each agreement, but we can have an additional payee added to the payment as a two-party check. Again, we only do one payment for a project, but with a two-party check, at least the landowner, if it were set up that way, the landowner would know how much his operator got paid for a project. And as I've said here, although the applicant may be the operator, the farmer may be responsible for the BMP maintenance, the landowner is ultimately responsible for the practice. Project monitoring during the life, as I said, either 10 years or 15 years. After the projects are installed, we cooperate with a process of with NRCS doing spot checks. This is shortly after the time period that they've been constructed, maybe the first year or so. And if we go out on the spot checks, again, as a team with NRCS to take a look and see how the projects are being maintained, or if it was built correctly. Each year we do a function that we call annual status reviews that is facilitated by the SCDs. There's about 500 active, or excuse me, of our 10% that we pull, it amounts to about 500 status reviews to be completed each year. The 1st of October, we'll send the status review reports, the blank reports, out to the districts, asking them to go around and do inspections on the projects. This is randomly selected. It's set up that, well, as far as randomly selected, probably from years, the 3rd year of the project to about the 14th year of the project, that's where we concentrate on doing the annual status reviews. So once if a deficiency is discovered during this process, then we ask the districts to get back to us within 15 days, and from there we take it over and try to explore, what the deficiency is, what it is that we need to fix it. Is it eligible for a repair, or is it the responsibility of the operator or the applicant or the landowner as far as maintaining it and getting the deficiency taken care of. With CREP project deficiencies for MAX, if they're co-cost sharing, I guess with FSA, the contract, sometimes the contract's terminated with FSA, but the MAX agreement may still be active. The deficiency may require a payback for state funds to MAX. If not, the applicant or the current farmer should be made aware of the MAX agreement, and the obligations to maintain a practice. So any new tenant or operator should be aware that the agreement requirements and also be aware of the NRCS standards. So with that, that's all that I had basically prepared for. At least you've got an idea basically how the MAX program functions, and we're open for business. Right now we're well funded. We're open 365 days of the year, so things are moving along quite well. Certainly practices in regards to trying to meet the WIP 3 goals are on our radar for right now. So that's all I have, Sarah.
Thanks, Norm. I appreciate that. That was a really good overview of the MAX program and some of the considerations that that landowners and farmers should think about, especially when they're talking about utilizing the MAX program on leased acres. With that, I would like to open it up for any questions that anyone has. You can go ahead and type those in the chat box. If you would rather correspond with one of us directly, here's all of our information, and we're all happy to help you. I did also want to mention that we are still creating resources for the agricultural conservation leasing project. So we are finalizing some one-page documents that we'll be distributing to soil conservation district offices and extension offices so that you can give those to farmers and landowners, outlining the project, as well as a one-pager that goes over some of the financial incentives for conservation practices, cost share options like we've talked about today, and federal tax breaks that you can get for, or deductions rather, that you can take for conservation practices. I would like to thank our presenters very much for their time today and the time they took preparing their slides. I will open it up for questions if anyone has any questions. Seeing none, I will remind everybody that if you did go to one of the workshops and you do help folks on this subject, if you have farmers or landowners asking you questions, if you're pointing them towards the guide, or if you're encouraging them to have a conversation with the other leasing party and you're helping them, please report that information to us because we have some grant reporting responsibilities. So there is an online reporting tool that's on the Hughes Center for Agroecology's website. I'm also happy to send anyone a hard copy if they'd rather use that. If you're having trouble finding the online reporting tool, or if you need any other form of technical assistance implementing the project, please don't hesitate to get in contact with me. Okay, thanks everybody. I hope you have a wonderful rest of the day.